Beckerman versus Ricky Conant et al. We are being streamed on the web both by video and audio now with our new camera setup. And if counsel would introduce themselves by saying their name for the record, together with the party you represent, starting with the appellant.
Your Honor, Nolan Reichl for the appellants Ricky and Monica Conant.
Good morning. I'm Peter B. Bickerman, and I'm representing the appellee Peter M. Beckerman this morning.
Thank you. We were a little confused. I'm like, wait a minute, I thought this involved Mr. Beckerman, and I see Mr. Bickerman in the back of the room earlier. Counsel, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court, Nolan Reichl for the appellants Ricky and Monica Conant. The underlying Superior Court case in this matter begins with docket number 12, which I highlight because the court should begin its analysis of the more recent contempt order by looking at what the nature of the underlying action was in the Superior Court. The underlying action in this case consisted of an effort by Mr. Beckerman to win the right to share in the use of the Conant's driveway. It was not an effort by Mr. Beckerman in any way to prohibit the Conants from using their own driveway to any extent. Mr. Beckerman never asked the Superior Court to specifically prohibit the Conants from taking any specific actions on their own driveway, which they undisputedly own in fee. And where Mr. Beckerman did not so ask, it is not surprising that Mr. Beckerman did not receive. And that brings me to the first error in the Superior Court's contempt decision. The law concerning contempt is clear. The language of the order at issue must unambiguously and indefinite terms encompass the alleged conduct. Where it does not, a contempt motion cannot go forward. Here, because Mr. Beckerman never sought any specific such relief, the April 2016 order does not include a specific prohibition on the Conants using their own driveway in any manner, including to park their cars or to place items. The Superior Court erred, therefore, when it allowed the motion to go forward. And that brings me to the second error in the Superior Court's decision. Not only does the April 2016 order not specifically prohibit the Conants from placing objects or parking cars on their driveway, one would not read that prohibition into the grant of the right that Mr. Beckerman received by implication. The mere fact that someone owns or holds easement rights over a right-of-way over another's land does not allow the easement holder to exclude the servient estate from its own use of its land. In fact, all of the default presumptions and rules cut the other way. The law is clear that it is actually the dominant estate whose rights are limited as much as possible in its use of the land, not the other way around. And that is unfortunately with the way that the Superior Court approached it.
Counsel, I see that the green light is on. Just to follow up on that last point, although the dominant estate may not be able to exclude the servient estate from the use, isn't it true that the servient estate cannot interfere with the deeded use of the dominant estate?
The servient estate cannot unreasonably interfere with the use of the dominant estate. And that's the key distinction that the Superior...
How does one reasonably interfere?
Perfect example. There is a fire at the Conant's home. A fire truck comes and parks perpendicularly across the driveway, blocking it in order to put out the fire. Mr. Beckerman shows up with his car, he cannot pass. That is an interference as a factual matter. He's not able to pass.
it's not an unreasonable interference. One could posit dozens of similar such examples. And the point, the error from the Superior Court, was whether it's reasonable or unreasonable is where the rub is.
Well,
But haven't we explicitly said in some of our cases talking about deeded easements that it is not limited to what is necessary or convenient or indeed reasonable? I mean, do we have cases that have said that it has to be reasonable?
Well, I want to be clear about the standard here, Your Honor. And this would be Drummond, this would be Flaherty, this would be Mill Pond. The dominant estate cannot unreasonably interfere with the servient estate cannot unreasonably interfere.
You can use names if that makes it easier.
The Conants cannot unreasonably interfere with Mr. Beckerman's right. That question of what's reasonable or unreasonable
But where is the case law that says that he cannot unreasonably interfere?
Drummond, Flaherty, and Mill Pond.
Can
Well,
you
Mill
give me
Pond
any-
has some language to the contrary. I mean, Mill Pond
Yeah.
says these are expressly deeded easements, meets and bounds, which is what we're dealing with here. The owner of the right is entitled to use the entire granted area and is not limited to what's necessary or convenient. And then further, where the bounds of the easement are explicitly described, the easement holder has the right to the full extent of the described land for purposes consistent with the easement. That seems to suggest that if I've got a 15-foot swath here, I can use the swath on the far left and the far right, and it can't be blocked. Am I overreading that?
I think you are, Your Honor, in a couple of ways. First, there isn't a meets and bounds description here. So
Oh, that's what we're dealing with, the driveway. But there's no doubt about where the driveway exists?
there is no doubt about where the driveway
Okay.
exists. But in Mill Pond, the Servian estate placed a sign in the right-of-way.
But I think the court took pains to say that this is just little things set off to the side. It really kind of de minimis. I think what we're saying, ordinarily you'd have the full right, but we're going to let you keep the sign because it's off on the side here. It's not a big deal.
And that's part of the reasonableness analysis. And I would point you to Flaherty, for instance. Here, Flaherty, they put a gate up, an actual physical obstruction. The dominant estate said, we don't like this. We have the right to use the easement. We have the right to pass. The point I want to bring this back to is the issue today isn't whether there's a dispute about where Mr. Beckerman's rights end and the Conant's rights begin, or vice versa. That dispute exists. There's no question about that. The Conants, of course, have a view about how that dispute should come out. Mr. Beckerman has a different view. The key point is that that dispute should not have been litigated in the context of a contempt motion. The contempt, the order from Justice Wheeler in April 2016 does not address any of these fine points.
Was that appealed? Wasn't that? Well, let me come back to this order. Is Mr. Beckerman taking the position, as far as you're aware, that the Conants can never park under any circumstances in the driveway?
Yes.
Well, that's not what his brief. That's not what the brief says.
Well, I think there's some dancing that's gone on in the brief.
Dancing, it's in the brief. I mean,
Well, I think what's clearer is what's his testimony on page 121 of the trial transcript.
right. He did say yes. You're correct. I did, in response to your question, but that does not appear to be his position, at least today.
I don't think so, Your Honor.
Okay.
What you've gotten.
Let me ask this. The Superior Court never said, did it, that the Conants can't park on their driveway. And I'm looking at the October 31st decision and order that denied the motion to dismiss. And Justice Cashman says, accordingly, the court agrees that defendants are not necessarily in violation of the 2016 judgment every time they park their car in the driveway.
Correct. And that holding should have been dispositive of the contempt motion.
Well, weren't there other facts at play in the contempt motion? I mean, the court made specific findings about specific instances where there, in the court's judgment, was a violation of of the order, of the judgment, that there was an unreasonable interference or an impediment by the way the vehicles were parked or by the way the dock was situated. I mean, those are findings by the court.
Two answers to that, Your Honor. First, when you say the court found that there was unreasonable interference, the court never applied the property law standard that requires a balancing between the two interests. So the court never assessed whether the Conant's use of the driveway was reasonable or unreasonable. The court treated the Conants as if they were a trespasser, and their mere presence on the driveway would be sufficient to demonstrate a violation of the order. So that balancing, the unreasonable question, was not assessed by the Superior Court, and that was an error. The second point, you asked, did the Superior Court take the position that the Conants can never use their driveway? I think that's a clear implication from multiple aspects of the ruling. One being the observation that the Conants diminished the viable area of passage. Of course, any entrance upon the driveway would diminish the viable area of passage. Secondly, the Superior Court held, that the Conants could comply with the order by parking the car off the driveway. So if that's what's needed to comply, if parking on their lawn...
Well, the court said specifically that they agree they're not necessarily in violation of the judgment every time they park a car in the driveway, and that the issue was whether the obstruction, whether it's by parking a car, putting the docking or whatever, blocked, impeded, or in any way interfered with the ingress and egress.
Well, again, the Superior Court, unfortunately, from our perspective, backtracked on the holding from the October decision. And we can see that the Superior Court comes to the opposite perspective, and this is on page 28 of the appendix. The Superior Court flipped and said, actually, the court agrees that the defendants don't need to completely block in order to violate. That is the opposite from saying that the defendants may be permitted in some instances.
Well, they said they don't need to completely block in order to impede. The court also said that doesn't mean that they can't ever park on the driveway.
Well, again, when the court rules that the way to comply with the order is to park the car off the driveway, that leaves the Conants going forward with really no options but to park the car off the driveway in order to avoid another contempt motion, this one being the third and a fourth likely to follow if they don't completely vacate the driveway. And to be clear, that was urged aggressively by Mr. Beckerman before the Superior Court on the contempt motion. It's in the trial testimony.
Well, it wasn't simply cars being parked in the driveway. It also, what the court found, there were instances where there was a movable dock that was placed that blockaded or at least inhibited the use of part of the driveway, and that there was ample space where that dock could be stored that would allow the ingress and egress that had been provided for in the 2016 order, which, as I understand it, basically precluded the Conants from interfering with the ingress and egress of the Beckermans to their lot.
Yeah. So those dock sections, Your Honor, the evidence at trial, there was no dispute about this. They were 5 feet wide and stored at a place where the driveway was 31 feet wide. So if the reasonableness balancing test had been applied, I don't see how the court could have concluded that that unreasonably interfered with Mr. Beckerman's rights to pass over the driveway.
Thank you.
See that my time is up.
Mr. Bickerman?
Thank you. May it please the court. Yeah, facts are stubborn things. John Adams said that in a courthouse not far south of here. Now, reliance upon facts may be out of favor in certain circles, but thankfully in courtrooms, facts still matter. Here we have a bunch of rhetorical dancing, speaking of dancing, by the appellants. But the fact is that their arguments are untethered to the reality of this litigation, both the procedural background and the evidence adduced during the contempt hearing. really where we have to start, again, we're not talking just about a general principles of property law or some kind of reasonableness test. We're talking about a specific court order from 2016 issued by Justice Wheeler, in which she said, among other things, that any injury by granting this easement and by granting an injunction for the benefit of Mr. Beckerman outweighs any injury the Conants will suffer because the injunction does not interfere
Mr.
with...
Bickerman, I see that the green light is on.
Yeah.
Can I go to sort of following up on some of the points from Mr. Reichl? I mean, was there a time, what we're talking about mostly here seemed to be that there was some availability in the driveway, but maybe not entirely. I mean, was there a time where it was proven that Mr. Beckerman could not go in and out of that driveway?
Yes. It's several times in the transcript of the contempt hearing, starting at page 64, going on page 125. There are examples of service truck being unable to actually service Mr. Beckerman's property, having to turn back up. There's another example of Mr. Beckerman's wife having to back up. These are in the transcript.
Counsel, what is Mr. Beckerman's position today? Is he claiming the absolute right to use the entire paved driveway at all times? In other words, is he taking the position that the Conants are not able to park their vehicle at any time for any reason?
What he is saying, there always are exigent circumstances, Your Honor, and it was, in fact, Mr. Beckerman said so in his testimony, the part that they're not talking about. And in our brief, there are exigent circumstances where cars could be placed on that driveway for limited periods of time, either to address emergencies, to service the property, perhaps.
Right, but Mr. Beckerman did say, the question was put to him, and your position is they can't park there at any time for any period of time. Isn't that right? Answer, yes.
And what I think we were talking about there was systematic parking, a parking plan, because what we know, Mr. Ricky Conant testified at the contempt hearing that following the court's order of 2016 and the law court's affirmance of that order, they didn't change. They continued their parking method, which involved a station wagon and a Silverado, a pickup truck, parked diagonally to reduce the passage. Now, that was, to us, in clear violation of the court order, which said you can't block, you can't impede, and you can't interfere in any way with the right of access.
Do you agree that one vehicle, for example, could be parked on the paved area of the driveway in such a way as to not impede or interfere?
Yeah, if they had parked, say, on the edges with the driver's side wheels on the paved portion, there'd be no contempt action here. That's not what they were doing.
What if the entire vehicle, the parts of this driveway are 30 feet wide? What if a vehicle is parked fully on the side of that driveway with ample space to get by?
That part that's 30 feet wide, though, is at the bottom. It's right near the boat launch. And part of this, of course, this all started with, of course, access to the boat launch, part of which is on Mr. Beckerman's property, part of which is Mr. Conant's property. They managed to get through launching boats without further litigation about that particular issue, though it did arise earlier. And so to the extent, even though it sounds very broad, during the time when the boats are being launched, being driven down to the boat ramp, any kind of obstruction of that area could be, in fact, a real interference. So it really, here again, there was a very broad, a very sweeping court order. To say that it was imprecise, I think, is ridiculous.
Well, how sweeping was it? In October of 22, Justice Cashman, her order says, and I quote, "The court agrees that defendants are not necessarily in violation of the 2016 judgment every time they park a car in the driveway," end quote. So how does parking a single car within the driveway block, impede, or otherwise interfere with Mr. Beckerman's ingress and egress?
Well, that would be, if in fact if that were the facts and Mr. Beckerman had attempted a contempt action, that would be a valid argument. But that's not what we're talking about here. And by the way, Justice Cashman's statement did not necessarily was made before she heard the evidence of what actually happened here, which was a systematic parking plan. They were using the Conants.
How often is Mr. Beckerman launching a boat?
Of course, in and out a couple times a year, but the testimony of the contempt hearings indicates it's an old boat, sometimes it breaks down. So there are a few times a season when, in fact, has to move that boat into dry land and ingress and egress.
Okay.
Again,
so
you need a loop, and in order to safely do it, you need that.
Can't there be some sort of communication ahead of time that would help clear the driveway if that was an issue?
No, because the position of the Conants continues to be, even as late as this contempt hearing, is if you ask us for permission, we'll do it. That's not what an easement's about. There's a deeded right-of-way. The dominant estate holder should not have to ask for permission every time the servient owner wants to use it as a parking lot.
It may not be a matter of permission, but it may be, I plan on taking my boat out tomorrow. Please make sure there's nothing in the driveway, since obviously you have a right to do that.
Well, again, let's put aside the boat. May I?
Well, but
there's
can we
evidence
put aside the
that
boat?
there's using one's car.
Well, wait a minute.
There was the gauntlet.
Hang on, go back though. Can we put aside the boat? I mean, the order from September of 2016 says it adds the language that the defendants have a right-of-way. Oh, I'm sorry, I take it, they have the right-of-way over for the boat. I got it.
Over the entire paved drive, by the way, says the order.
Flipped the other way.
Said the order. And the Conants, though they appealed the 2016 decision, never appealed based on the scope of the injunction. They didn't raise a single issue about that, nor did they ever move the court to alter or amend that judgment. And so that's when we talk about res judicata, and I agree our brief used res judicata too many times as a term, but when they use the term res judicata, that's it. That ship sailed.
Did either party request further findings of fact?
No, not on this, and they didn't request further findings back in 2016 either. They didn't request further findings here. There was on 2016, there were other motions that aren't pertinent, I believe. I don't want to get into it in my limited time, unless you want me to. But look, as Justice Cashman found, after hearing all the evidence, defendants park their vehicles on the driveway within the paved area on both sides in a manner that impedes plaintiff's right-of-way and makes it difficult, if not impossible, for him to pass at times. Again, they have not challenged any factual findings made by the trial court here. That is the law here. Instead, they want to talk about general principles of reasonableness and property law. And I'd be happy to speak to you, and if I have the time, I will, about how the Flaherty case is distinguishable, as is the Mill Pond case. In Flaherty, goodness, it was a walkway, a narrow walkway easement where a gate was installed, but each easement holder was given a key. All they had to do was take the key out of their pockets, unlock the gate, but it wasn't even operative, by the way, at the time of the litigation. The gate had not been closed. Here, as an analogy, are the Conants going to give Mr. Beckerman keys to each of their cars so he can move their cars? And I'm sure they wouldn't like that. Needless to say, it would also expose Mr. Beckerman to liability if something should happen while he moved their cars. I mean, there was no reason, and as the court further found, there was no reason to put the cars that way in the driveway. There's room on their property for at least 12 vehicles. That is, again, a matter of record. And so the facts here just tell us that there was a deliberate non-compliance with the court order of 2016, a deliberate decision to, I would say, toy with Mr. Beckerman, make his life difficult, and, you know, a civil contempt proceeding.
Is there anything in the record that indicates more precisely when Mr. Beckerman's life was being made more difficult?
Yes.
Yes. Let me finish the question. Other than the context of moving the boat down to get to the dock,
yes,
and in having service people come to the property that could be alleviated by just giving, if not asking permission, just giving notice that we've got this going on at this, coming up shortly. Can we just work this out?
If you're asking me about the history of when this became more difficult, I can explain. It's in the record. I'm not. If you may be asking a different question, which if I don't answer, please tell me. In fact, Mr. Beckerman testified that there was a dispute arose. He bought his land. Beckerman bought his land in 1988 and was using that paved drive, not infrequently. From then on, the Conants bought their land in 2005. In 2010, the Conants began cutting mature trees within the shoreland zone. Beckerman reported this to the authorities.
Well, so I can move you on in the history. I'm just talking about ingress and egress, which I understand to be related primarily to moving the boat in and out or having service people take down trees.
At that point, and Mr. Conant testified at the contempt hearing, said, yeah, when this tree cutting thing happened, I decided to put a gate in. I wanted to put a gate in. And that's when that 2000 litigation that resulted in 2016 court order, how that ginned up, that dispute.
Counsel, there's another means of egress and ingress to Mr. Beckerman's property. Is he using that? How frequently does he use the?
Occasionally, but it's a steep hill. It's not wide, maybe 9 feet wide. There's a steep grade, and near the bottom of it, there's a very sharp turn. So you're going down. While you're going downhill, you have to go about almost 90 degrees to turn. So it's not particularly safe, especially, I have to say, as someone who myself, I'm over the age of 70, as is Mr. Beckerman, these things become increasingly unsafe. So it is it's not a way that works with service vehicles at all, with any kind of width vehicles. Okay. And so we have these situations in which this isn't just a question of what's reasonable, it's a question of whether there is a court order, which there was. It's not ambiguous despite all the protestations. No one is telling Mr. Conant or Mr. and Mrs. Conant they can't use the driveway. They can use it for access. That's what it's for. It's for access to and from South Crane Lane to their property.
Well, just to be clear about this, though, do you agree that the Superior Court essentially said that the Conants were not being prohibited from parking on their driveway?
In the prior decision, before there was a factual hearing,
yes,
Justice Gifford said, this doesn't necessarily bar you from parking.
Correct.
I would, though, and again, there always are exigent circumstances.
Well, I'm going to suggest that was actually in the final order as well.
Well, I would say, again, the final order dealt with the evidence of what was really happening, which was systematic use of this driveway as a storage dump and a parking lot.
The injunction specifically provides that the Conants are permanently enjoined from blocking, impeding, or in any way interfering with the right-of-way.
And they interfered here.
Correct. I understand that's your position. I understand that's what the court found. That does not permanently enjoin the Conants from parking their vehicle as long as it doesn't block, impede, or in any way interfere with the right-of-way, does it?
And I don't disagree, but that's not the case before us. We didn't, Mr. Beckerman is not asking for a further injunction that's even more sweeping. He's simply saying that what the Conants did is in contempt.
And so what you're saying is, even without deciding that question, what the court found is that they did, in fact, impede, block, or interfere with the right.
At times they blocked it completely. At other times they impeded, and at other times they clearly interfered in some way. The court's order
without having to necessarily determine what the outer fringes, if you will, that in this case the court found, and you think that that was sustainable on the evidence. Is that right?
Yes, exactly.
Okay.
I see that my time is up.
It is. Thank you.
Thank you.
Mr. Reichl, I think you reserved 2 minutes.
Thank you. So what we just heard from Mr. Bickerman is that in exigent circumstances, maybe it's okay but if it's near the boat ramp, it's not okay.
But is that a question we need to determine here today? I mean, what the order says is that they have the right to use it for ingress and egress. And what the court in the Superior Court found on the motion for contempt was that, in fact, that they had interfered with their rights of ingress and egress.
So the Superior Court erred because the permanent injunction issued by Justice Wheeler does not prohibit the Conants from parking on the driveway.
But
But that's not the question.
It
It
is the
does
question,
prevent
Your
them from, it does prevent them from blocking,
Right.
impeding, or interfering, does it not?
It says that they cannot block, impede, or interfere with the right of Mr. Beckerman.
Correct.
What the scope of that right is was not decided by Justice Wheeler.
But the court made a finding that, and there was no request for further findings or elaborations. The court made a finding that your clients blocked, impeded, or interfered. Did it not?
The court made a factual determination about what the Conants did. The court erred as a matter of law, both when it did not find unambiguous language in the 2016 order, and when it did not apply the appropriate property law standard to whether we had unreasonably interfered with the use of the driveway.
Well, the court had testimony, the court had photographs, there were videos. The court could see what and hear what happened, and it made a determination based on that.
And the
Correct?
court applied the wrong legal standard to that determination. There's no dispute about the facts here. The underlying facts, the Conants parked on their driveway. They did that.
Well, they did more than that. They parked two vehicles side by side with a very narrow passageway in between at one point.
We disagree with that, Your Honor, but thank you very much for your time.
Thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issue a written decision in due course. And with that, we'll be